Again, good morning, everybody, and welcome. My name is Tanya Ash, and I'm Director of Programs and Member Engagement here at World Trade Center Denver. This webinar is part of our Tariff Navigation series delivered in partnership with the Colorado Office of Economic Development and International Trade through the state's Economic Resilience Technical Assistance Program. We know how challenging it is to manage costs and risk when the trade rules keep changing. As we know, just last night about Tariffs 122. So the goal of this series is to give you practical strategies around sourcing, classification, and compliance, so you can better plan and respond. For 40 years, World Trade Center Denver has supported companies navigating imports, exports, and global operations. All over the past year, we've worked closely with hundreds of businesses, specifically on tariff-related solutions. In addition to these webinars, we're also offering direct support. Through OEdit, qualifying companies can access up to $1,000 matching reimbursement grant to help offset consulting costs. If you're interested, you can fill out the request form in the chat. So if my coworkers can put a link there so people can grab that form if you need one. To schedule a chat, an initial discovery call to see if that would be a good fit. Before we get started, please take a look at our upcoming sessions. So this is, let's see that, there we go. So this is our fifth session, and we have one more coming up on June 5th with Tom Cook on foreign trade zones. So make sure you register for one. That one is in June, so a couple of weeks from now. And now it is my pleasure to introduce today's speaker, Dave Glenn. He's also our board member at World Trade Center Denver. He's an attorney with Holland and Hart. He has recognized expertise in conducting detailed internal investigations and audit related to export controls, trade sanctions, and custom laws, working with clients in development, drafting and implementation of compliance programs in various areas of federal regulatory law. He utilizes his extensive experience in export management systems and import compliance programs to help his clients to achieve their goals. Dave, I'm going to turn it over now to you.
Great. Thank you, Tanya. Welcome, everyone. I'm going to start sharing here. Find my sharing settings. Hold on. Just have my sharing up here. There it is. Let's go to the share that. I'm going to just do it here. And I'll probably have to switch my display. Okay, there we go. Okay. I'm going to talk today about trade enforcement, tariff enforcement in general. So the thought behind this presentation was really to get a status update on where we are with import compliance enforcement overall. It's not just focused on tariffs, I'll tell you that now, but that's a primary, a focus area for the government now, as everyone kind of knows. But let's go ahead and get started. I wanted to start with just kind of laying the groundwork here for the agencies and the folks that are involved in U.S. import enforcement. Primarily, it's U.S. Customs and Border Protection. Everyone knows CBP is kind of the gatekeeper, right? So they promulgate the regulations, they enforce them. They are at the ports. They are the primary enforcer. Now, that's primarily on the civil side. So as far as U.S. import law goes, we have both civil and criminal penalties. And of course, the criminal penalties can bring prison time. So there is a distinction. There's a knowledge factor that goes along with criminal that you don't have on a civil fine or civil penalty. So that's under Department of Homeland Security. On the right side, you see Department of Justice. I put that department up pretty high as well. In fact, on par with Customs, in that any criminal investigation that's going to happen on the Customs side and import, DOJ is going to be involved in that. And typically, some other agencies within those departments are also involved. You might have Homeland Security investigations, again on the criminal side, and the FBI is involved in these situations. So we're dealing with a violation of U.S. law, but also some national security concerns that happen with U.S. imports as well. So that's kind of the ground level where we start with the folks that are looking at looking at your imports, and enforcing these laws. What I have here is kind of just a summary of some of the things we're seeing these days. And again, these probably won't surprise you. If you've been reading any media, you'll see that we're seeing penalties, we're seeing settlements issues that are arising coming out of the new administration. A little different focus. The laws aren't really all that new. The tariffs might be a little new, but the laws in import compliance are really not that new. They've been around for a long time. But they're getting enforced, and the focus is a little bit different than maybe in previous administrations. What we're seeing here too is more cooperation between the agencies. This happened also on the export side with U.S. export compliance, but it started to happen this year, or really last year, with import compliance. And this trade fraud task force that started last August was to get together, the DOJ and Homeland Security, kind of coordinating and saying, hey, this is a joint effort. We really need to enforce these laws. And a lot of focus on revenue, right? Tariffs and duties. So that's where kind of a focus with misclassification. So I assume the audience is probably pretty well aware of imports, but every product coming into the U.S. has to be classified, and there's a harmonized tariff schedule number for every item coming in. Using the wrong tariff classification, and specifically to try and evade tariffs or duties is illegal, of course, and that's what they're trying to root out. Undervaluation is the other one. These tariffs, these duties are based on, an ad valorem. It means that, percentage of the value of the item. So a lower value, lower tariff, right? A lower duty collected. So looking at fraud in that area. And fraud, by the way, I'll talk a little bit about what the standards of culpability are here. But fraud is kind of the highest level, saying, hey, you knew what you were doing. You did it intentionally. So there's some thought behind it. It's not an inadvertent violation. The other area is transshipping, and I'll show you some examples of that. But transshipping is really where you're trying to avoid the true nature or the true location of where the item was made. Typically, most of these tariffs are based on country of origin. It's a product of, say, product of China. That means it's country of origin China. That's what we're looking at. Transshipping an item made there into Singapore and then sending it here saying it's Singaporean origin is illegal, right? Just to avoid tariffs. Mislabeling goods with different country of origin, the wrong one. Then when we get down to the third bullet, it's kind of interesting. This is a trend we've been seeing over the last several years, reporting and whistleblowing. So the False Claims Act, it's a U.S. law that allows what we call relators, allows people to, it can be either an individual or it could be an entity, filing suit on behalf of the U.S. government to try and claim back some illegally provided funding. And that's usually what happens is you're cheating the government out of, say, a government contract. When applied to imports, it's really, we call it more of a reverse false claim action, where the government is coming in and saying, you cheated us out of the tariff that was really due. Right? So it's not that we paid you on a government contract too much, it's that you haven't paid us enough in tariff or duty. And you did that, to evade these tariffs. What happens with False Claims Act actions, really, the government can recover quite a bit, 3 times the underpayment of the duty and civil penalties. And then the person that turns in the offending company, the whistleblower, is actually eligible for some recovery as well. So there's kind of an inducement there to turn these entities in. So we're seeing a lot more false claims actions happening with inputs, which was a relatively new trend in the last, I don't know, maybe 4 or 5 years. And the bottom line is it's really here to protect revenue, right? It's the way the government will put this. We're protecting revenue of the United States. And it's really important that, if we have a tariff out there, that you pay your right amount. Not a whole lot different than, IRS and paying your taxes, right? They want to make sure that your correct amount is there. So we're looking at tariff and duty payments. I'm going to talk about refunds in a little bit since that's a hot topic. There are also some enforcement implications on the refunds process that's happening, and we'll get to that. Here's the list of CBP priority trade initiatives. This list, I will tell you, hasn't changed much in probably, I don't know, 5, maybe more than that, 5 years. It hasn't changed. I just want to make the distinction here that we're seeing trends, but they're not focusing on all of these trade priorities like they used to. They're focusing on a few of them, right? So you can talk about agriculture and quota, and that's an important enforcement area, but it's not getting the attention that we're seeing in some of the other ones when we're talking about revenue and trade agreements. So I'll show you how that works, in practice, what we're seeing. I wanted to just show you an example of some of the settlements that we're seeing on the criminal side for U.S. import violations. Again, this is kind of the higher level of penalty. This is saying, this entity is alleged to have done the action with knowledge. So they were trying to evade tariffs in tariffs or duties in some way. And if you look at this list, I've highlighted there the bolded comments kind of show you the particular focus areas that we're seeing. So in the first one there, it's a Section 301 tariff evasion. 301 is the tariffs that we've had on China that now we're investigating in other areas that could go global pretty much. But tariff evasion on some shipping. So again, that's the trend I talked about earlier, shipping from one country to another to try and evade or change the country of origin. You can see a $54 million penalty there. So pretty big, pretty major. Again, the task force is looking at these kind of items. The next one talks about misclassification, right? So classifying automotive components as something else that had a lower duty rate, lower tariff, $53 million penalty. These are significant in terms of the level of penalties that we're seeing with customs these days, as opposed to you look at some of the other ones, they're little older ones, and $4, $5, $6 million penalties, significant, but not quite the same level as what we're seeing more recently in the December timeframe. Again, we have anti-dumping duty evasion. That's another one. Anti-dumping is really a duty that's put on items that are being unfairly traded, that are being produced and sold in the U.S. at an unfair value that is below cost. And that's a key area to protect U.S. businesses, obviously. And that's also considered duty evasion. You don't pay anti-dumping that's due, you're evading the duty, and that's also illegal. Then the False Claims Act, and I talked about that. Oftentimes that's country of origin matters, where you intentionally, in this case, with criminal, intentionally mark the country of origin as something other than its actual where the item was produced, where it became an item of commerce, the substantial transformation where it went from components to the final product. That falsely declaring that can have a big impact on the tariff or duty you pay. And then valuation, again. So you can see the theme here. It's pretty obvious what they're looking at and what they're focusing on. I think it's also obvious from this slide that they're being effective, right? They're being effective in rooting out some of this fraud. I'm sure they're not catching it all, but they're rooting out a lot of it. And this slide really just talks to the standards of care and the civil penalty amounts. So now we've moved from criminal to civil. And you can see the levels, they really start there at the bottom. We talk about negligence as being kind of the lowest level. If these violations are strict liability, if they happen, it doesn't matter that you didn't know the law. What that will affect is which level on this scale you fit into, right? So negligence is just failure to exercise this reasonable care. Reasonable care is a concept really that talks about, the U.S. importer has a responsibility to know what the law is and to follow it. And some steps like, putting in controls, putting in compliance programs, using experts, getting a ruling request, things like that go to the reasonable care standard. But it's saying that, if you had an error, it's strict liability and it's a failure to exercise reasonable care because you made the error. And you can see the penalties there. And go to 5 to 20% of the value of the merchandise or a half to 2 times the duty. Typically, what happens there is if an item is duty free, they'll go to the value of the merchandise penalty. If it's dutiable, they'll use the duty penalty. Gross negligence, you can see the standard, it's without actual knowledge or want disregard. So little higher level, the government has to have a little more evidence to prove that you're beyond just failure to exercise the reasonable care. And then fraud is at the top. As I mentioned, fraud typically will go to a criminal penalty, but there are also civil penalties for it, and pretty severe. So those are the three levels of culpability that we have under customs law. And that's what these agencies are enforcing. They're looking at that, and then, of course, going on the fraud level to get to a civil penalty or a criminal penalty. Now, just some input from CBP that they put out recently in terms of penalty statistics. There's been a high enforcement volume, a lot of trade enforcement penalties happening, even in the first half of 2025, over 1,400. And they're saying the projections are to surpass previous years. So Customs is coming out and saying, we're gonna issue more penalties. We're gonna go out and we're gonna root out more of this fraud or the errors in the system. The penalty types, they start pretty low. They can start at $5,000. The importer security filing is really just that pre-arrival information that you send to customs so that they can screen. $5,000 for those. But you can get, as you can see from penalty, criteria just listed, get a lot higher than that. And then the rising cost. Look at the money they're collecting. It's kind of interesting, $37.9 million, 46,835 liquidated damages claims. And liquidated damages is really where the government comes in, indicates you made a violation, you had an error, and they want to collect on that. So typically that's the value of the duty that they lost, and then maybe something else. And they typically start with those at full value of the item itself, and then they can be mitigated down. And then on transshipment, so this again is the situation where you would move from a product from one country to another, really to evade the tariff or duty on the item coming in. Some transshipment is legal, right? So it's not illegal to say you have a feeder vessel coming from somewhere in China and it goes to say South Korea to get on the main vessel to come to the U.S. That's not illegal to do that. What's illegal is to say that, hey, my product was made in South Korea, when actually it was made in China. That's the illegal part. So that's the transshipment we're looking at. And it's tariff evasion, right? So we're looking at the 2025-26 statistics show, over $400 million in unpaid tariffs were recovered. So again, this is that task force going out looking at customs, looking at that data that you're sending them at a time. They're finding anomalies. They're finding things that they look into and discover that there's tariff evasion going on because the goods are being transshipped. And here are some of the countries. I put those up there. They're in there really to kind of trigger. If your supply chain involves these countries, Vietnam, Indonesia, South Korea, those are the ones that at least in 2025 were found to have been involved in transshipping. And again, not the countries per se, but it's the entities that are doing this frauding. You can see the volume of the penalties, they're fluctuating, 2,500, about that annually. The penalty rates, that's an interesting situation with the tariffs that came about. There was a 40% penalty put on transshipments if they were discovered. So the customs is coming back and saying we're really gonna hit you hard Those tariffs went away, but there's still the focus on, we don't want you transshipping just to avoid the penalties. And we talked about what those might be. You can see the collection amounts, from these trade penalties, 19 million to 46 million annually. So it's significant in terms of the collections that they're getting through this enforcement, uh, you know, uh, focus. Seizures at the bottom there really just talking about how, goods that come into the country that do not get cleared, they don't get cleared, they get seized for various reasons. And the note here really talks about being non-intellectual property related. So there's quite a few seizures that go on that are related to, violation of a patent or a trademark. It's, counterfeit goods that are coming to the U.S. You probably hear about those pretty common, type, at least in the past, common type of seizure. But we're seeing non-IPR seizures. So we're seeing it for other reasons. We're seeing it for forced labor and for other reasons that are not related to intellectual property. And that's a fairly new trend in terms of, the fact that it's growing. And you can see the millions that are being collected through that. I wanted to talk a little bit about tariffs since that's always a hot topic these days. The Section 232 tariffs, those are the ones that were put in place on originally steel and aluminum, starting back in the first Trump administration. Copper was added in this new administration, and we're talking about derivatives as well. These are items that contain steel, aluminum, or copper, but they're not, solid, a metal themselves. So in beginning of the month, there was a a presidential proclamation came out, and it changed kind of the approach to implementing these Section 232 tariffs. What it did, it really expanded some of the compliance exposure. It tried to, I think, simplify some of the ways that we determine the tariffs. But it also, I think, added a little level of increased level of enforcement capability for the government, particularly around, how accurate is your metal content declaration, and if it's by weight or valuation, and then again, transshipping. And I pulled out this quote actually from the Federal Register notice. I think it's significant because again, it goes to the same thing, right? That I keep reiterating here in this program, but the same thing, we're going to address illegal transshipment, undervaluation, and tariff evasion methods. So they're telling us, the government is telling us this is going to be a priority. They've set up certainly methods and resources to go out and root this out, find it, collect it. So it's there, and it's happening even in these tariff programs, not just in the regular customs regulations that again have been pretty static for many years. And following on that, I think it was significant also that when we saw the tariff refund, so everyone knows the IEEPA tariffs were ruled invalid, illegal back in February of this year. And the court came out and said, the Court of International Trade said you must refund these tariffs. They have to go to everyone. So that's still being potentially will be appealed, but that's where we are today. And the system was developed in the customs system, the automated commercial environment, developed kind of a module called CAPE, this Consolidated Administrative Processing of Entries, they call it. But what it is was developed in what appeared to be a very short time. It was deployed on April 20th, and it is in process, it's being working, and it is processing these IEEPA tariffs for importers to pay them. But what was interesting, I think, in what came out here, they didn't just come out and say, here's the system, this is the information we need, file your claim. But what they wanted was a certification. And you can read that, but it's asking the importer to attest, that the country of origin is correct. Remember, we're talking about, evasion, the entry type, the harmonized tariff schedule, the classification, the valuation is correct, true and correct for every entry. So they're coming right out and saying, it's important that even when you claim a refund, that you do it accurately and that you will certify that it is accurate. And unfortunately, at the very end of this, I highlighted some of the language that talks about the penalties, right? You're subject to criminal and civil penalties if you don't get this right. If you intentionally make false statements, you could be liable for a criminal penalty, civil penalty if you just make mistakes. So, and you can see some of the statutes there, the regulations that they're talking about. So I think what it does, it sets you on notice that you want to make sure that when you file these claims, they're correct, right? They're accurate. You might want to audit them. You might want to look at them a little more closely than just preparing the list, which is really all they ask for. Talk a little bit about audits and penalties. Audits, again, they don't, Customs doesn't have enough resources to audit every importer. They're certainly not going to do that. But they are stepping up their audit reviews and increasing, the volume of them. So they're really sophisticated in data analysis and targeting. I know they were using some AI for other areas in customs. I think they're probably using it here. But they're trying again to identify, the highest risk areas. And they have something called a focused assessment, which is really looking at an individual importer, looking at their profile, looking at what they import, and targeting where they think, there may be non-compliance. Increased audit frequency, you can see that. The scopes are a little broader. I will say they also have some more focused, even more focused than a focused assessment, looking at maybe one issue in a company. But again, looking at is there any violation of trade law that we need to look at? And then, it just underscores, again, reasonable care that I mentioned, the reasonable care standard. You've got to have good programs in place, good compliance procedures and process, and do your own audit. As far as some of the statistics, as of April 2025, they've collected over 134 million in duties. What happens on these audits is that they will find errors. Oftentimes customs, the auditors, it's a regulatory audit of a particular function within customs that does this. Typically what they'll do is they'll allow you, if you find an error, to go ahead and disclose that error and pay the tariff that you owe, the duty that you owe. So that's where they're recovering a lot of this. If you don't do it voluntarily, they won't do it in other ways, right? They will make it mandatory that they will turn it over to the enforcement arm to collect those tariffs duties. You can see the audits that were identified and the enforcement focus. Again, I keep repeating it, right? Tariff classification, valuation. Every audit that I've been involved with that I know of focus on those two areas because you can guess why, right? It's revenue. So they're looking at that. And then, the tariffs, the section tariffs, section 301, 201, 232, all of those, what do they go to? They go to revenue. So, customs was originally established as, a revenue generation, agency. They were part of the Treasury up until 2001. So that was their primary focus. They'll tell you now that is not their primary focus. It's one of them, but it's not the primary. It's obviously protecting the U.S. homeland, but certainly it's a key. And you can see the penalty activity, the recent data on the number of penalties issued is going up. So I'm getting near the end just to kind of wrap up a little bit here on some mitigation strategies that you can look at to really help avoid this. I do a lot of work with companies after they've gotten in trouble, right? So we defend companies, we help with enforcement actions and really trying to mitigate any sort of penalty or issues that they might have to resolve those. So we do a lot of that work, but what I tell clients really is start early, start up front, and do it proactively. You have this standard of reasonable care. In reasonable care, I do a class with World Trade Center every year, and I go into reasonable care in a lot more detail, talking about how it's really not clearly defined in the customs regulations. It is really a concept that is kind of thrown out there, and there's no step-by-step approach that you can do that will say you absolutely met your reasonable care standard. But there are a lot of other pieces to put into that puzzle to say we're building it's not based just on one factor. We'd look at the entire list of things, the entire complement that you've got in your process to show that you've had reasonable care. And that's things like, having records, hiring licensed customs brokers, monitoring those brokers and making sure you understand what they're doing on your behalf. That they aren't making errors. Because as the importer, you'll be responsible for those errors. Classifying goods correctly, and country of origin, obviously, is going to be another one. And that kind of gets to the second bullet there. Actively engaging with your foreign suppliers. You want to not only verify the accuracy of the documentation, but of the country of origin as well. So what you want to do is to look at, where are you sourcing from? Are you sourcing from a country that's manufacturing the product? Have you verified that their documentation says that is the country of origin? We are seeing instances where, these foreign suppliers trying to help out the U.S. importer say, well, we'll just, we're going to ship it through, a third country, and it'll reduce your duty, and we'll mark a different country of origin. That's a problem, obviously. So understanding, where your product is made, and making sure that the documentation is correct, is all key to that process. I mentioned audits and reviews, and really looking at what's being submitted. I talked about the IEEPA tariff refund statement, the certification statement. But actually, we've had a certification on every import declaration that you've made forever, pretty much. And it's on the entry summary that your broker typically submits for you. They're acting as your agent, but they're signing on the bottom line, not necessarily in pen and ink anymore, like back in the old days, we used to do that, but they are signing that everything in there is true and correct. So the standard that I was kind of talking about with the IEEPA tariff refunds really isn't a whole lot different than what we have today. But I think the exposure is a little greater in that instance, especially because of, you're giving money back, right? You're not paying that. The same thing happens here, though, with entries, right? They want to make sure that you're paying the right amount of duty, tariff, and then any of the fees that get calculated as well. So you want to audit that, make sure that you know what they're doing. Supply chain mapping kind of goes to the transshipment issue again. It also talks to forced labor. I didn't mention that in here, but we do have forced labor laws that prohibit entry of items that are made with forced labor. So in that, again, the law has been around a long time. It got beefed up, and a new provision put in place on China, the UFLPA law that really prohibits imports of items made in the Uyghur region in China. So that was pretty specific, but forced labor is a global issue. And we're also, I mentioned some of the 301 investigations going on. There's one going on now on forced labor, looking at countries that maybe the U.S. government thinks are not enforcing the forced labor restrictions as tightly as we think they should. And the outcome of that may be additional tariffs. We don't know what will happen there. That's still ongoing. So understand where your product's coming from, map it, make sure you understand where the suppliers are, and that the information that's getting reported is correct as well. ACE, the automated commercial environment, is the customs system that's used for all your filings, and your broker typically will have an interface to the customs system to actually do the filing for you. However, a few years ago, several years ago now, customs actually opened this up to importers and said, you can have your own portal. You can look at your own data. You can go and do analysis. You'll have all that information. You can use ACE to actually talk to customs and submit documentation. So it really kind of opened up a whole new area of electronic information that really was available to importers, but not readily. So in the old days, we used to actually have to go to ask customs, give me a report of all my data, all my imports over, X period. And they could do that. But now what customs is saying is you need to get an ACE portal. And you can get your own data. You can run your own reports. And there are canned reports in that. But I recommend that you go in and look at that pretty frequently, at least, annually, maybe semi-annually. You look at that, start looking at your information and understanding what is your broker reporting for you, right? You can also do this by looking at the paper documentation coming in from the broker, but I think looking at it in a report, you can actually scan and look to see, are they claiming some kind of FTA program that we're not eligible for? Are they claiming, country of origin of a country we don't deal in, we don't think we buy from, we don't think we manufacture there? Those kind of things you'd be able to identify and get ahead of customs. Means you don't want the task force coming out and knocking on your door. And then finally, what happens when there are issues? So this can come in a couple different ways. You could, through your ACE data review, through your audit review, identify errors. And customs knows that there will be errors. They actually expect errors. They know that these laws are complicated. They expect errors. They actually make some errors on their side. Well, another discussion, but they know that this is complicated. So they expect you to identify errors and come and correct them, right? Come in, fix it, and correct them. And that is the part where we get into prior disclosure. We're going to look at kind of going into the government and saying, oops, we made a mistake. It was inadvertent. It's just a little negligent error. And we want to fix it. Here's the tariff. Here's the duty that we owed. And, interest with that. And you close out the matter that way. I do a lot of those for companies. Very effective way to close out and to avoid penalties. With prior disclosure, if it's done properly, there are no penalties. You just have to pay what you owed and some interest on that if you owe interest. I mentioned the mitigation guidelines here because there are errors that customs will discover and they will tell you about. And they typically do this through issuing a penalty notice. Often this will come initially by some inquiries that they make to you. They'll ask for information or request for information, and they'll look at this, they'll find an error, and then they'll correct the error on their end, but then they're going to come back and say, hey, we're going to issue a penalty. And there are mitigation guidelines. So because they recognize that these are, complicated rules, they have a very set, structured level of mitigation guidelines that definitely you want to look at if you get, say, a penalty for, an ISA failure, that didn't get, your import security filing didn't get done timely. Or I'm dealing with one now on wood packaging material. I didn't mention that there's some other agencies that control imports, and one of them is the Agriculture Department. They're looking at wood packaging coming into the U.S. There are pretty strict requirements on how that has to be treated and then labeled, as treated. And if they find, a pallet coming in, a wood pallet coming in that isn't properly marked, they will issue a penalty. So, but there are guidelines that say, hey, all you have to do is go petition and say, hey, I want to have this mitigated down, and they will do that. So that's the final page that I have for you to take a look at. And that's just some resources. I think, I'm not sure if this is going to be distributed, but here are the resources that you can look at. Informed compliance. When we came about with reasonable care, the reasonable care required the U.S. government, the customs, to actually tell you what the rules were, and they called that informed compliance. So what they did is they published a lot of these guideline documents. Some of them are a little older, but they're really good instructional information in those. I recommend going and checking those. They have them on valuation and classification of a lot of these areas we've been talking about. Anti-dumping, countervailing, you can go look to see if your product might be subject to that. That second link there probably is a little better because that goes to the International Trade Administration, which is the Commerce Department administration that actually manages all of these anti-dumping, countervailing orders. Regulatory audit, if you want to look at what that is, I recommend regulatory audit because there's the focus assessment I mentioned is an open book test. They will tell you what they have a checklist. They'll tell you what they're going to go through. I recommend you doing that yourself, even before you get audited. Prior disclosure, there's information on that, and then the mitigation guidelines at the bottom. So that is pretty much all I have online. If there are questions, I'll be glad to take those.
Fantastic. Well, thank you so much, Dave. Again, for everybody who is joining us today. Dave is one of the best here in our network. So if you have any questions or if you have any sort of concern, what Dave was talking about, I actually put a little note here. I said, get ahead of customs. And I think this program, and this is what we're doing today, is exactly to help you with that, especially with the support of OEDIT and the $1,000 stipend that we have. So again, thank you, Dave, so much. And everybody, if you have any questions, please put them in Q&A session. And I also would love to get Emma Howard from OEDIT join us and tell us a little bit more about the initiative that she's running.
Hey, real quick, Tanya, we have a question in the chat here.
Oh, we do?
Right. Yeah, I did see that. Yeah. So the question asks about using a third-party importer of record to reduce your enforcement exposure. Well, yes, the importer of record is the primary responsible for compliance with these regulations. So again, that's the certification saying everything is true and correct. However, there have been some cases, and there was a case a few years ago where a party did this. They intentionally told the foreign shipper to mark down the invoice, to put inaccurate values to save tariff. They hired a party to be the importer of record, and they did this all as, part of a scheme to evade duties at that point. The government came out at this court. This case went right to the Supreme Court. This case went up, and the government said that because that entity that actually managed this whole thing, that ordered the product and had the invoice made false, because they introduced the shipment into the U.S., they were liable as well for the errors, and they ended up getting the penalty. So I would say no. Hiring a third-party IOR is not really going to reduce your exposure if you're planning on doing something that's illegal, right? If you're above board, everything's correct, and you just don't want to have that responsibility, then that's an approach. But I would not assume that you're going to fade into the woodwork and not have any liability if, in fact, you engineered the whole, evasion type situation. That would be my thought on that. Hopefully that helps.
Thanks, Dave. Yeah. Any other questions, Andrew? Or I think I looked through the chats. I think we'll look good there. Oh, we have another question. Yeah. Dave, go ahead.
Sure. DDP, delivery duty paid. So that's an INCO term. And what DDP means is that really the responsibility for import compliance is really with the seller, right? So if you're talking about two parties, the buyer and seller, and the seller would be responsible there to import. Yes, that responsibility would be with them. The importer, the buyer, takes delivery at the named point, but it's in the U.S. after clearance. So yes, the responsibility then is with that seller under DDP. So it does relieve, and a lot of companies go to DDP because of that. They just don't want to have the liability for customs compliance. Now, it's potential that the buyer could do something to cause a violation. Like I said, actually tell the foreign party to mark down the invoice, put the wrong country of origin, transship it. They could actually do that if there were evidence of that. And I think there would be some liability. But ordinarily, no. DDP is your safest mode to kind of get away from the compliance responsibility for any sort of import action.
Thank you, James, for your question there. Good to see you there. All right. Well, thank you so much. And again, if you have any other questions, feel free to email us. Here's also Dave's information, or you can also reach out to us. And I do invite you to schedule that phone call with us, discovery call, and we'll have a link in the chat here shortly. But with that, let's all say thank you to Dave again for preparing all this information and guiding us through the through the regulatory and different regulatory bodies and how to stay compliant. And let's turn it to Emma. Thank you, Dave.
Tanya. And thank you so much, Dave, for your presentation today. I'm sorry I had a meeting this morning and missed the beginning, but I have heard great things about your presentations from past events and look forward to reviewing the recorded version. So thank you for being here, and thanks for World Trade Center for hosting. My name is Emma Howard. I am the Senior Manager of Strategy and Special Projects at OEdit. And I wanted to just briefly speak about how this program came about and what opportunities we have both through our partnership with WTC as well as at OEdit to help Colorado businesses navigate this ever-changing trade environment. So we started this program as a response to an executive order issued by the governor asking OEdit to study the impact of the tariffs and the changing tariff ecosystem on Colorado businesses. From that, we identified some of the major challenges and decided to team up with World Trade Center to address those challenges by providing these webinars to reduce the uncertainty that businesses are facing, and by providing these subsidized packages that Tanya referred to earlier and Karen so helpfully put in the chat. I really encourage businesses to take advantage of those packages. You can work one-on-one with experts in the tariff and trade world to mitigate risk, lower costs, save on fees and fines, and do so at a subsidized cost using some OEdit dollars. In addition, outside of the partnership with World Trade Center Denver, we also have a number of access to capital loan programs that we offer that can be applied to support some of the work that you all may be doing to mitigate these tariffs. And please feel free to reach out to me if you have any questions about some of those lending opportunities. We also offer general business advising through our Small Business Development Center. Regardless of where you are in the state, you have access to small business advisors that can support you through any number of issues as it relates to your business, or just help you get ahead and do some long-term strategic planning. So this is really more holistic business advising, but there are a number of free resources through the SBDCs that you can access to ensure that your business is resilient regardless of the challenges and obstacles that pop up as we continue to exist through this tariff ecosystem, and of course through the summer that we are expecting with drought. So please make use of those resources, and please feel free to reach out to me if you have any questions. I will pop my email into the chat, and I hope you all have a great, fantastic rest of your Friday. Thanks again to Tanya, Dave, and the World Trade Center.
Thank you so much, Emma. Yeah, and SBDCs and OEdit have fantastic resources again, and please do use those, because I think, all of us are working together here in the ecosystem. When you win, we all win. So with that, I wanted to leave you with 3 things this morning. Number one is we actually have a training coming up on supply chain tracing. It's May 13th next week. So if you are a member, you probably have credits. So again, use those credits, and if you don't know, just reach out to me and we'll make sure to get you registered. Number 2 is our largest event of the year, World Trade Day, is on May 21st. We hope to see you there and meet you in person. And the last one is the last webinar in this series is on June 5th. It's going to be on Foreign Trade Zone with Tom Cook. So challenges and opportunities. Make sure you register for that, and we'll see you on June 5th as part of this series, or in person during the World Trade Day, or again in some of the other events that we have around the city. Thank you so much, everybody. Have a wonderful Friday. Bye.